We'll start having court on Saturday and Sunday. Yeah, well, that's my call. So if you don't want your Saturday and Sunday sucked up.
We think about 150 witnesses, Your Honor.
150 more?
We are losing our jurors. They are trying their hardest. Often they are taking notes, but other times they have just tuned out. Tuned out.
Day 52 of the Young Thug YSL RICO trial consisted of a few motions. One about the admissibility of lyrics and another about how many more witnesses the state will call to testify. District Attorney Love is asked by the judge how many more witnesses she will call, and she responds 150. This basically means that it's going to be another 6 months of the state calling in witnesses to testify in front of the jury, which obviously means the jury is going to get tired of this and want to live their lives. So this is useless. This is pointless. The worst trial of all time. Hit subscribe. Here we go.
In regards to the court's earlier rulings consistent with the lyrics and songs that I said that the court will preliminarily admit subject to a foundation.
Always subject to a foundation. All right.
There has been a case by the name of Baker. I'm willing to give you 30 minutes apiece because I've read Baker, and of course I've already made a ruling. So it doesn't really require me to get spun up or educated that much on it.
This is about the Baker case that I made a video on about a week or two ago, which was different circumstances. The guy had a gun and a music video, but he wasn't the artist or anything, and he was just standing in a music video with a gun, and they showed that to a jury. He ended up getting convicted, and then now it's being overturned, I believe.
In the Baker case, Your Honor, I know you've read it. Baker was not a gang case, not a RICO case, not a conspiracy case. A RICO conspiracy case, I understand that. But it did involve the playing of just a video, what was deemed by the Supreme Court of Georgia, a rap video. No lyrics, because the lyrics were not understandable. We note that the probative value of the rap music video was further diminished by the state's failure to present any evidence that Baker's performance of Crawford's rap song was not wholly theatric.
In this particular case, the state has said, look, we're gonna tie this to some aspect of membership, of leadership, and other things that are required to be proven under the gang statute. So tell me if you could distinguish that for me or talk about that.
The video of that guy holding the gun should have never been shown to the jury in that other case because it wasn't really proving anything regarding that crime. But this crime is a gang charge, and these guys are talking about gang shit in these songs. But a lot of the lyrics the state has in this case, there isn't much of a nexus. I would imagine Brian Steele's going to say these lyrics have to be connected to an actual crime, like they have to connect the lyrics to one crime.
I don't believe that the state will show any type of nexus, and in New Jersey versus Skinner, SKINNER, rap lyric evidence that provides direct proof against a defendant, such as an admission or details that are not generally known and dovetail with the facts of the case, should be analyzed for relevance under 401. And what I'm saying here is, Your Honor, the state can't do that. When we had that last hearing, it went till late at night, the state was saying things like, and I'm just using out of the indictment, I ain't killed nobody, but I had something to do with that body. They just said, there it is, Judge. That's what we're saying. We're saying that Mr. Williams' hands are always clean and he has other people kill for him because he's the leader. That lyric, first of all, is used in other songs, which I've mentioned to court previously. But in addition to that, that's not something that's unknown. There's no details. There's no nexus. This honorable court, to admit that, is just admitting the artistic work, doesn't know if it points to any type of killing.
That's kind of true. Like, there's not an exact connection between that lyric and a crime, a specific crime, and the indictment.
It just goes to propensity, and I believe under Baker, 403 analysis should shield it. To answer your question, I hope I'm answering, but the state can't do that. They didn't proffer to you anything that would associate these lyrics with a certain crime. The closest they came is they told the court that Trestle Tree, that Jeffrey Williams said the word Trestle Tree, which is a section, a street where crimes were committed in this case. The fact that he is using Trestle Tree in a song certainly cannot be that he's somehow involved in that crime. The prosecution spent 4 months showing or trying to show that Mr. Williams is the leader of this gang. They have put on over objection Mr. Bean's recorded statement with Detective Quinn saying that Jeffrey Williams he commands Mr. Murphy to do something. They put on Trontavious Stevens, who said inconsistently, but said Jeffrey Williams is a member of the gang. So why did the lyrics have any probative value if it's simply cumulative? I'm trying to answer your question, but my point is to use the art to assume that is statements that the state argued are confessions. That's what they said. These are confessions. We didn't go out and find them. Mr. Williams, handed them to us. These are his inner workings of his mind. But it's an artistic industry that our courts now, for the first time, this is the first time in Georgia, our court has said in footnote 16, we got to be careful.
Brian Steele's pointing out some good things here, but I still think the judge, he's already made up his mind. He's going to be like, this, I'm just going to let him in, even though some of them should be taken out that are irrelevant and not really connected to anything.
The following, based upon our independent review. I'm sorry. Yeah.
Did bro just pick up an iPhone and take a call in the middle of court? What the f are we doing? Is that his personal phone? I know I say phone weird. I'm from Maryland. There's always a few comments. Let's first look at Thug today. He's got a nice suit on with the tie, looking clean.
In fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because the author has chosen to write about certain topics, he or she acted in accordance with those views. And all I believe is going to happen is you play those videos with those lyrics, where you have somebody say, here are the lyrics taken out of context. then the jurors will be horrified and be prejudiced as was in Baker.
Now Shannon Stillwell's lawyer, Max Shard, is up. So I think he's gonna play either a song or a video here. So this guy's got a YSL chain on. Flat Talk is the song name. So he's talking about keeping a stick on him, wiping his nose.
Your Honor, that was the song.
The same shit that got Big and Tupac killed. Look, push that get your bitch ass. Hey, gang, you bring push that out here. You gonna see me? I'm at your next.
You talk about Tupac there? The same shit got Tupac killed, I think.
All right,
So that's Stillwell too?
that is Stillwell too.
Some outstanding citizens just yelling at the camera. I don't see nothing wrong with it.
I think we need to ask what the state's theory of admission is. What is the direct nexus? What nexus is there to any allegations in this indictment, any crimes? My stance is just because the state pleads something as an overt act doesn't make it automatically admissible. It's listed as an overt act, but it has no ties and no nexus to any substantive offenses. Allegedly wearing a YSL necklace, and he's allegedly wearing red. I believe he says the plug, but essentially robbing dealers or distributors. He boasts of keeping a stick, which common parlance is an assault rifle, on him. And he says, I just beat a murder rap, paid my lawyers $30 for that. None of those statements. Robbing distributors, that has no direct nexus to any substantive charges in this case. Keeping a stick has no direct reference to any charges in this case. I just beat a murder rap, paid my lawyer $30 for that. Now, I think it's fair to say that that is most likely a reference to being wrongfully arrested back in 2015 for the murder of Donovan Thomas. He was arrested in October of 2015. He stayed in jail for a long time as his co-defendants' cases had their preliminary hearings, were dismissed. Eventually, the state dismissed cases. All three other individuals that were charged in that case, along with Mr. Stillwell. Mr. Stillwell was granted bond, as artists do in their expression in hip-hop. It may have been a certain level of fictionalization because we know, in fact, it was not dismissed. He was, in fact, on bond. That is not in any way an admission of guilt. That is just a statement that I was wrongfully arrested in the past. I paid my lawyer for that. I have no idea how much he paid the lawyer. It wasn't me at the time. Artistic freedom, and also, even if it is based in some facts from his past, it's not an admission to anything. It's completely irrelevant. It's just saying I've been arrested and I beat the case. And it becomes harmful with the next line where he says, me and my slime's above the law. It becomes the idea of bragging, of boasting. That's where the prejudice comes in. To the jurors, oh, you think you're above the law because you're rapping about being wrongfully arrested, now you're free. Evidentiary value to any substantive charges in this case. Not an admission, it's not intrinsic, it's not 404B. It's just wholly irrelevant to this case.
Your client's statement potentially of I beat a murder rap might be an admission.
That's not in dispute. He was arrested for murder. I mean, that's known. We're going to talk about it. He was wrongfully arrested for murder in October of 2015.
Isn't that one of the predicate acts that?
It is, but I don't see how acknowledging that you were arrested for the murder and either released or
But you
beat it.
sang about it though, and in that for the jury to determine.
That one is close to being admissible. I mean, I honestly don't think any of the lyrics should be in, but at a certain point, if the judge is ruling that they're coming in, that one's pretty close.
I mean, they can look at it for several reasons, for a couple of reasons. One, he's membership. In fact, he's wearing a YSL chain.
Okay,
Two, that he's wearing red, and three, that he's rapping about a potential issue that he's been involved in.
See the relevance of me in a book saying, oh, I was arrested for this. We all know he was arrested. He was arrested for murder. He was charged with murder. That's a known fact. I don't know why we need this song to be admitted to show that he was.
Was there a trial on the murder?
No, this is the trial.
Okay, all right.
Bro self-snitched. Is it an admission? No, I don't think it's an admission, but it's definitely not a good look for a jury to see that you're bragging about, you know, beating a murder case when you didn't even beat it. You were out on bond. We all know the way judge is going to rule on this, right? Like, this is...
I don't believe it's relevant, but we'll talk about the probative value.
Okay, but remember, in Baker, the person wasn't even in the video, right?
He was.
In Baker?
Yes, he wasn't the artist. I think the gentleman's name was No Cap.
I can't believe No Cap's getting brought up in here. That's the Baker case. No Cap had a music video. I think it was it the Ghetto Angels video? Friend shot some security guard or something outside a nightclub. Nothing to do with the case, but he's in the video with a gun, and they showed that to the jury. Crazy.
The gentleman, Mr. Baker, was in the video dancing with a firearm.
But that particular individual neither authored the lyrics or the views or values reflected in the video were adopted or shared by the appellant.
It is different, but man, it's close.
That's pretty. I mean, the jury could consider that as a statement against interest, right?
No.
Okay, well, we're going to disagree. We're going to disagree about that.
So if I said,
well, it wouldn't be wise for one to say I beat a murder rap and the prosecution's still open.
The judge made up his mind, but he said I just beat a murder rap before he beat it. So now a jury could see that, like, self-snitching, dude. You cannot speak about open cases ever.
I mean, they had beef in this particular case because it was minimally probative. In this particular circumstance, I think that they've tied, along with the client wearing red, client wearing YSL t-shirt, shirt, and then rapping with other arguably members of YSL about a potential crime that he may or may not involved in. Now, the jury can decide that that's not what it stands for, and they're gonna in weighting the evidence. But
Talks about being arrested. And that is not an issue. He has been arrested. Nowhere does he say, I committed a murder on that video. If he said that, we'd be in a much...
That's a good sentence right there. I'm like starting to sway with the lawyer a little bit more now. Like, he's just talking about being arrested.
And he's wearing red. If that's what this is really all about, A, they could just show a screenshot of wearing the YSL necklace, and that would equally prove the point. B, they could show any of these other pieces of evidence.
That's another good point. Like, they could just show the necklace picture, but...
That
is robbing the dealers and carrying a stick part of the homicide, the alleged homicide?
No. No.
Okay.
The awkward silence.
Danger of unfair prejudice. I think Mr. Steele talked about it. Obviously, references to robbery, and I think that's pretty self-explanatory.
But the lyrics in this case are not being offered to show propensity.
Well, then let's redact them. Let's redact them. If that's not the point, let's take out references to robbery. Let's take out references to a stick. If it's that simple.
I can just tell Miss Love's so mad down here in the bottom left. All right, state attorney is up.
So the broader realization I'm having as I'm hearing these defense arguments, Your Honor, is that this Baker case came out, and it's a case that applies 403, but it doesn't change the law on 403. I think we're getting arguments that, Baker came out and there's this case where a rap video was excluded, so therefore that's now a change in the law that means all rap type evidence is now radioactive under 403. That's a flawed proposition. Automatically operates to vacate this court's lyrics order from November. That's not the case. It doesn't suggest that. It certainly doesn't compel that. The sole enumeration of error in Baker was the trial court abused 403 in letting this video in. But meanwhile, what it does show, and what my colleagues have pointed out, was that it does show Baker dancing and brandishing a semi-automatic pistol with apparently an extended magazine, and he's pointing it at the camera, at the jurors when they watch the video, and they watch it 3 times, okay?
Why would they do that in that other case? That was so stupid.
It was proof essentially of nothing, Your Honor, and it became a central focus of the case in Baker. It's not a lyrics decision, Your Honor, on imagery. It literally says, the lyrics have no bearing on our conclusion that the rap music video was improperly admitted. That is highly important. I didn't hear any defense address that.
Shit, yeah, this judge ain't ruling in favor of the defense here, boys. It's over. That one statement right there in Baker, it's all about the visual part of them seeing the guy pointing the gun at the camera, and it was shown to the jury 3 times throughout their trial, and that's why that conviction was overturned.
In Baker is that it's, again, it's a single defendant murder trial, whereas here we got a multi-defendant RICO and gang act prosecution. Williams' motion says, oh, it's no difference that he's charged under RICO and gang acts. It makes all the difference in the world.
Big gulp of water. Bro got thirsty.
So the lyrics evidence in this case, already properly admitted, relates to, just as a reminder, the nature and existence of the alleged criminal enterprise / gang, the affiliations with the alleged criminal enterprise and gang, participation in the alleged criminal enterprise and gang association and membership, participation, and the connection of the defendants with one another.
Each side is pulling me to each side. I'm like, oh, I'm in favor of what the defense lawyer is saying, then now this guy comes up and I'm like, shit. But this judge had his mind made up in either way.
How much you paid your lawyer, you're bragging about money, and then you're bragging above and beyond that. You're not saying me and my slides follow the law, which goes to the mindset and intent. And so it all goes to count 1 and then some.
But it's an art form. Like, bro could just be cap rapping. Or how do you know he's the one that even wrote this? There's ghostwriters, bro. Look at Shannon. So this is all about him yapping, self-snitching on himself. He is not looking happy right here, boys.
he's robbing dealers, okay? I mean, and he carries a stick. The last thing is I beat a murder rap for 30.
The robbing drug dealers and carrying a stick shit is kind of irrelevant.
I mean, what about the robbing dealers and carrying a stick?
Yeah.
Should I exclude that?
No.
Yes.
Well, it provides evidence of the nature and existence of the organization.
That's why I asked Mr. Sharp. Did the homicide occur as a result of robbing a drug dealer, or was it allegedly Mr. Stillwell carrying a stick?
Well, there had to be some sort of weapon for this murder to have occurred. I don't have any specific nexus about why sort of words before the words that are admissible are specific to this, but we do have an entire overt act.
He's struggling with this response right here.
And the things that are said in context, right before, right after, sort of the YSL associations, especially even in the Stillwell 2, where you have YSL for life, and you have blood love all the time. You have all these indicators of this is evidence of the organization.
I get all that, but the specifics of robbing drug dealers and this defendant's reportedly carrying a stick, what relevant? I mean, that could potentially, I want to parse out those 3 statements.
Yeah, those 2 are, and of course Miss Love's getting involved because she sees her co-counsel right here struggling.
But I do think that you're going to need to address the issue of the robbing dealers and carrying a stick, unless you're going to, like I said, lay more foundation in regards to that.
We have allegations that Dirty Red is a dealer. We have Donovan Thomas, who was murdered with an assault rifle, and there's indications that it's a rival gang situation. So it's not maybe
the issue with Donovan Thomas hasn't come up yet.
Well, they're talking about the stuff they do. I mean, talking about the way they do it. These are parties making statements about the things that they do. It's highly probative. Oh, the jury's going to be inflamed. We have to shield them from these facts, these things, these statements, these words that the defendants uttered.
These facts. They're saying it's an admission. Are rap lyrics all facts? No. I guarantee you there are some rap lyrics that aren't true. So he's saying they're facts. Not necessarily.
You have to admit it for tying to some specific or linkage from some particular nexus.
Well,
so
I'm
that's
gonna default
why
back.
I'm telling you that, you know, it's got it's that's why it's important.
I'll just default, Your Honor, back without wasting any more time. I'll default to the idea that it's an admission of a party concerning the nature of the enterprise.
Is it admission of the enterprise existing? Because these could just be individual crimes. Like, it doesn't mean that it's linked to YSL as enterprise. Bro was out there robbing and killing people. Was Thug saying, foot soldier, go kill them? Probably not.
Probably about 15 minutes. I need you take comfort, and I would encourage y'all to do the same.
All right, Judge Glanville's got to take a shit. Here we go. An hour later. So an hour long shit for Judge Glanville. Must have been a rough one. I understand, Judge Glanville. You know, every once in a while there's a shit that where you got to get completely naked and scream for an hour straight.
In particular, the court failed to do a 403 analysis, much differently than this court's analysis. This court did a fairly exhaustive analysis as is contained in.
And he is denying it.
There are differences in the factual predicate as alleged and as applied in Baker. Nexus that was much weaker than in this particular case at hand.
So he thinks that there's more of a nexus with these crimes and lyrics than the other case.
I'm going to deny Mr. Williams. I will authorize the state to, consistent with my earlier rulings,
So I have to lay foundation, subject to proper foundation.
subject to a foundation. Folks, what I'd like to do is, since we have not taken lunch, is to maybe for us to take about...
We just took an hour for this. Surprisingly, like 55 minutes later, not 40 minutes, but now he's writing shit for 15 minutes. Thug is laughing about something. Why Thug look at the camera like that?
And up to this point in time of April the 2nd, I should say, 2024, we have summoned some 40-something witnesses at this point in terms of just a rough framework of what has gone on in this particular case. But there seems to be two issues and two categories that issues kind of get presented. Even though the state has released tranches of discovery over the course of the past year, some of it is untimely, and it causes, this is information evidence that the defense claims that they haven't seen or has been augmented.
Wow, looks like the judge is finally getting mad at the prosecutor for giving discovery in the middle of a f***ing trial.
And a big example was last week when we had the testimony of Ms. Bennett, and even though there were interviews and or text messages that were available, they were not disclosed until the witness was on stand. The state could have and should have provided those particular statements earlier. When we have a jury seat in the box where Sergeant Ingram is right now, and I say, is there anything else that we need to take up? I'm really just kind of being polite. I really am. I really don't expect you all to have anything other than maybe something that's ministerial in nature. Ms. Love, I asked you to, have you gotten the list of potential witnesses and the days you think you're gonna take to present to the rest of your case in chief? Just ballpark. Okay, all right. I told you to have it today. Okay, and this is one of those things that I tell you all. I mean, it's just like what I tell you all is not aspirational. There's a reason I ask you for it, and this is exactly what I'm complaining about at this point. You told me you were going to have it because I told you we were going to have, first we're going to have these motions on Monday and Tuesday, but unfortunately I had a funeral I had to go to yesterday. At least a week or so for you to pull this together. How many days more of trial do you think that your case in chief will take? 30, 40, 50, 60? Tell me how many more days you think you're going to have. I asked you to come up with that number because that's... All right, just sit there and think about it. I'm going to come back to you in just a second, okay? But this is a challenge because...
We're 40 witnesses in and you apparently have 400 or some shit, dude.
We have jurors that, we need to present this case in a more expeditious and streamlined fashion. And this is just part of, when I ask you to do something, please do it timely. And this is a problem. We're going to come back to this, all right? I am going to apply 24-6-611.
He's going to do something about how long this trial is going to take with the witnesses?
I'm going to initiate the follow-up. On Mondays, Thursdays, and Fridays, we're going to start at 8:45 and reclaim a little bit of time. 2 is going to be the exclusion of any evidence, documents, or pictures that aren't timely disclosed. If appropriate, and I do need to take up something that is of that important or import, I will go ahead and excuse our jurors.
Jesus, that might even extend the trial even longer. Like once or twice a week, the lawyers have something to discuss suddenly. He's going to excuse the jurors instantly and then no more testimony for the day. Jesus.
4 is I have spoken with our sheriff, and consistent with the court, if necessary need be, we'll start having court on Saturday and Sunday. Yeah, well, that's my call. So if you don't want your Saturday and Sunday sucked up, I think we need to work a little harder, being able to streamline, and that goes to both sides. And look, I don't want to work that way too, because it's me and my staff and my team and the sheriff and his team and everything else. But we will do it because we're going to have to recap some days. I don't want to be in 2027 trying this case. Or as Mr. Steele said, I want to be here next Super Bowl trying this case.
Honestly, kind of a W. You don't have any off days, motherfucker. Dude, the jury's gonna be livid.
I shouldn't be having these many discussions, interruptions. I mean, and I'm in no way saying you're not doing your jobs, because that's what you're paid to do. You are doing your jobs. But ask, Ms. Love, how many more days do you think that you'll have?
How many more days for the state's case in chief? Here we go.
How many more days and witnesses do you think you'll have?
We think about 150 witnesses, Your Honor. And
150 more? We've only had 40 and it's taken 52 days.
Have you all, now is this 120 days of actual, like 5 days a week or what?
Right. We were trying to, this is what we were trying to achieve.
That's gonna take 6 to 8 months more. Someone in chat said the judge on the computer ordered dinner already.
The number of witnesses, this is the most pared down. This is what we expect that we hope to be able to prove everything that we intend to put before this jury in our case in chief with these witnesses.
I want to see 150. I want to see them in terms of law enforcement and what they're going to testify to, and lay witnesses and what they're going to testify pursuant to counts, overt acts and/or counts.
Putting his foot down on organization, and now the defense can be more prepared each week. You know what I mean? They see what they're going to call and like, okay, this is what we have to work on this week.
So that I understand, the court isn't asking that we give the strategy to. The court is just saying, generally speaking, this act, this, that, this, the other.
At this point, there's not any. One of your predecessors told me once, said, "I'll give you my entire file because if you can beat me with it, you deserve to win." And I think at this point in time, the caliber of lawyers that you have in this courtroom, there should be no surprises. And I'm of the opinion that more disclosure just fosters openness in the proceedings. Here's what I don't want to hear. Ms. Hilton, a couple days ago, we just found this last night on the person's Instagram.
Your Honor, so
okay, that's
oh yeah, that's crazy.
it had just recently been posted.
well. Then you should have grabbed that, and whatever time that it was given to you, if it was 6 o'clock in the morning, should have been forwarded over to them so they can kind of say, "Look, this just got posted, whatever else." Then that's kind of everybody knows. Everybody knows you're probably going to introduce that evidence, and then they can talk with their client, whoever else that posted it, and they can kind of say, "Well, they can have meaningful discussions."
We're just asking that that be required of both sides, so that
And as long as it falls within the rules of the rules that remember, they're not in their case in chief yet, and they don't have to do anything. So
yeah, he's asking for the defense's tactics. They haven't even done their case in chief.
the rules don't necessarily apply to them the way they apply to the state. At this
Yeah, thank you, Judge, for putting your foot down on that. She's trying to get defense tactics. This lady dirty as hell, bruh.
And I know that's frustrating, but that's just part of it.
When the state says they have 120 days of direct examination, that's 120 court days, correct? So we're looking at about 6 months more of their case in chief, assuming we ask 0 questions on cross-examination. 120 days, is that 4 months? Or is that, if we're going 4 days a week, for example, are we talking 30 weeks?
we're talking 120 days.
120 court days.
Are you talking about 120 court days?
We have to add in our cross-examination. So we're here with the state's case in chief through the Super Bowl.
That's 6 months.
Or more.
Yeah.
Okay.
And Your Honor, that is
I love how the Super Bowl is the time period that they keep comparing it to because it started in January and it's around January, February. But whatever. That shit's funny.
it's not precise, and I can do more. It's as precise as I can give to the court at this moment.
So she bullshitted. She just admitted that was not precise and she's just bullshitting, giving him an answer, and she's not right.
Courts in the 11th Circuit, the 7th Circuit, the 5th Circuit, the 3rd Circuit, the Western District of Pennsylvania, the Northern District of Iowa, the Eastern District of Kentucky, the District of Mass, and I could probably go on and on if I had more time to research, have used the combined power that you have under 403 and 611 to limit witnesses, limit the number of witnesses, and or put time limits on the state. I would just ask the court to reconsider, because I do appreciate that you're trying to grab the bulls by the horns here, make us more efficient. And I don't doubt that those rules that you've put in place will make us more efficient. We're still trying to be more efficient at something that is going to go on for years. This length of time doesn't include our cross, and it doesn't include our case in chief.
Oh my God, that doesn't include cross-examination. This trial is going on for at least another year. At least another year.
I cannot ask for what I asked for under 403, fine. Okay, why don't you put in time limits? It's done over and over again by courts, Your Honor. Right now, 150 witnesses, 120 court days just of direct examination. We're going to be making Super Bowl bets with each other in 2026, Your Honor. Don't misunderstand me. I understand that you have exerted control. But what I ask is that you listen to what some of these other courts have done. Unless you exert some type of limit, we are never going to get through this. Even working on the weekends, we are losing our jurors. We are losing our jurors. I look over there at them and they are trying their best. They are trying their hardest. Often they are taking notes, but other times they have just tuned out. Tuned out. In a study from 1987, looking at long trials being more than 20 days and short trials being less than 6 days, in long trials, 46% of the jurors found that evidence was difficult or very difficult as compared to jurors in short trials, 29% in short trials.
I've been saying this. The longer this trial goes on, the more likely there's a not guilty verdict because these f***ers are going to be zoning out and saying, "F*** this. Not guilty." I don't remember what you showed me 8 months ago.
Here's the thing I'm most concerned about, Your Honor. In long trials, 46% of jurors had their attention wander quite a bit or occasionally. And these studies were done back in the 80s.
Oh, Jesus. Now it's even worse. Social media and everything. Attention spans.
In 2004, the average attention span that you could focus on something, an average person was 2.5 minutes. Now we're down to 47 seconds. So these jurors in the 80s who found that their attention wandered, they're not even close to not wandering anymore. I'm really afraid that what we're going to end up with is a situation where the jurors are making their decision
decision, not based on 2 or 3 years of evidence presentation, but on how well the advocates do in their closing arguments.
Good points from Mr. Weinstein there. Great points. I mean, this trial is a disaster.
We're asking a lot of our jurors. So I want you to really look at the number of witnesses you are going to call.
Also extends to repetitive questions asked by counsel for multiple defendants. And so, Your Honor, we would ask that the court also
cross-examination has not been the cause for delay here at all. Repeat questions by the defendant's lawyers is the issue too. That is the most delusional statement I think I've ever heard in a courtroom.
Fashioning remedies that include when there are questions asked by one defense counsel that another 3 cannot get up and ask the same thing, though they are representing different people.
The nerve for lawyers to come up and ask on cross-examination questions that another lawyer asked, but they want to get the point across that their client's innocent. This is your fault for putting all of them on one trial, low-key. They have different clients. Each lawyer has the right to come up on cross-examination. That's insane. That just triggered me. This bitch has some nerve, dude.
Yes, Mr. Weinstein.
Your Honor, I don't believe it can be the additional element that the state has asked for that you put in there that we cannot ask redundant questions. I believe the court has done a...
Well, I'll interrupt you because, yeah, I mean...
Court's shown that you are willing to jump in if you believe our questions are redundant.
So, Your Honor, Jimmy Winfrey is a co-indictee in our case. He is obviously not here.
This is about Jimmy Winfrey, the guy, I think his nickname is Pee Wee Roscoe, was the guy that shot at Lil Wayne's bus. Thug was never arrested or anything involving that shooting. So, like, how are you going to say all that?
He was previously arrested and indicted, and that is for an April 26, 2015 alleged shooting at a tour bus that was occupied by a performer, Dwayne Carter, known as Lil Wayne, with very fine lawyers, and he pled guilty. He then appealed with another very fine lawyer, different lawyer, that his guilty plea was coerced by the trial court, and the Honorable Court of Appeals of Georgia disagreed. The Honorable Supreme Court of Georgia agreed with Mr. Winfrey. They vacated and said that the trial judge got involved was coerced the plea. So I've always objected that co-indictee who's not testifying that their guilty plea is confrontation clause. It should not come in at all. But in this particular case, Jeffrey Williams' name is placed in the original indictment, and an indictment is the prosecutor's hearsay. It's rank hearsay. That's according to State versus Brown. I don't want Jeffrey Williams' name to be in it. He was not charged. He's not pled. He was not arrested.
Completely understand Brian Steele's point of view there. His client's name is in all this when he was unindicted, not arrested at all.
The shooting of Lil Wayne's bus is not only alleged to have been done by the criminal street gang member of YSL, that is Jimmy Winfrey. It is also alleged as an overt act in our indictment. They do reference Mr. Williams, Your Honor, because Mr. Williams, as alleged in this indictment, was a part of the act that Jimmy Winfrey committed when he shot at the bus that was Lil Wayne's tour bus. Mr. Winfrey is a co-indictee, gang member, and member of the criminal enterprise that is Young Slime Life. The state's position is that the state is entitled to show that Jimmy Winfrey entered a guilty plea, and Alfred plea does not negate the fact that it is a guilty plea. Your Honor, our intent is not to call Mr. Winfrey. Our intent is to prove up the case that Mr. Winfrey was to present evidence independent of the indictment itself. And we'll be putting up the evidence that shows that what is alleged and to the counts that he pled guilty.
That's Mr. Winfrey, that is.
Your Honor, we will be showing not only Mr. Winfrey, but the association with various members of YSL.
Yeah, but he's not in this trial. That's what the judge keeps saying. The association doesn't really matter.
But here's the thing. The indictment references Mr. Williams, who was not on trial for that case.
We'll be proving what is alleged in the indictment regarding Mr. Williams as well. We'll be proving it with witnesses, not just with that certified document.
She is reaching with witnesses that Thug was involved. Come on, bro.
But I think that you would probably have to redact out Mr. Williams' involvement at this point.
All right, that's pretty much it for day 52, a day of motions. I mean, this trial's going to be happening for the next year, is my guess, which is just fucking ridiculous. I don't know if I signed up for this. Hit subscribe, comment down below your opinion. Love you guys. Peace out.